Hey guys, what's up? Santa Claus came a little early, brought me a new desk, so I have a little bit of a different setup. Nobody's here yet. I know this is kind of a crazy time to schedule a live stream. I usually don't do live streams in the evening and not on a Sunday, but I was just looking around YouTube and I saw a new case that I think we might want to look into. It's Brian Walsh. All I know about this case is that he murdered his wife, allegedly murdered his wife. That's all I know. And I found his discovery hearing and I thought we might be interested in it. So I decided to schedule a live. And nobody's here yet, but I do have 3 likes. So I guess y'all come back and watch it later then. So let's go ahead and get started.
I see this case going in terms of progressing forward and discuss your joint motion that you submitted last week and a preview for that. I guess I don't see this case going into 2026 for a trial. I think it should be tried in 2025. I'm certainly going to do my part to make sure that it keeps on track to get us there. And that's due to, in large part, the age of the case and its respective complexity or not, and the range of cases like it. So I think that it's reasonable to assume that a case such as this one will be tried within 2 years of indictment on the present schedule or looking there that you suggested. I think it's coming closer to the 3-year mark, and I think that's a little unnecessary. And nothing gets better with time. People's memories don't get any better, and the case isn't going to get any stronger. People's memories fade over time, and so I've been interested in making sure the case gets tried as efficiently as is possible, respecting the numerous issues that have to be addressed. So we'll talk about that. And then I think attenuate to the motions that have been filed, we're going to need another date, or perhaps need another date on the Rule 17 motions, which I appreciate the defense filed to come up, I assume, based on your earlier pleadings, and third parties may be filing objections to those, so we'll get that on the calendar. With regard to the calendar, I'm happy to come down here today. As you know, I have been specially assigned. I want you to know when we're picking dates for future things that it's highly likely you're going to be traveling. I'll try to travel here when I can, because I know that this is where it is. But you should also build in the expectation that you may be traveling, and the travel in the next 3 months is going to be to Middlesex County, because that's where I'm going to be assigned for the first quarter, and deliberately not far from here, recognizing that I probably would be seeing you a bit between now and whenever we get the case ready for TF for trial. So let me say that just so that you sort of have an idea of what my knowledge base is, and I've gone back and tried to listen to a number of the hearings on the case, most notably, I guess most importantly, your last hearing before Judge Cannone, when this issue with regard to, I think as Attorney Tipton said, it was an exhaustive or extensive discovery request came up, and you all thought that you could make some.
Whoa, that's a familiar name. A familiar? That's a familiar name. Judge Cannone. Okay, wait, I gotta back it up. What did she say about Judge Cannone?
On the case, most notably, I guess most importantly, your last hearing before Judge Cannone, when this issue with regard to, I think as Attorney Tipton said, it was an exhaustive or extensive discovery request came up, and you all thought that you could make some headway, and you did make some headway, although there's some disputes that still linger. At that time, so I listened to that last hearing. I also went back and listened to a hearing on June 24th, in which we were first, the parties informed the court that the trial date was too tentative at that point.
So Judge Canoni was the judge in the last hearing on this trial? Is that what she just said? Darn it, where are you guys? I need you to interpret these things for me. That's why I like to watch them with you. Why have y'all bailed on me?
At least 6 months ago, anyway. I have before me now what are the first round of discovery disputes. Those were docketed just for the record. And as paper number 18, the defendant's motion for discovery of documents related to the district attorney and law enforcement. That then gets updated by your second motion, which I got to be filed on Friday. That's paper number 32. I've gone through those. I've gone through the Commonwealth's oppositions to those. And then also I received on Friday paper number 31, which is, I'll call it the federal investigation motion, and the Commonwealth's opposition to that, which I just briefly, I got it just as I was coming down the stairs, and I read, but I haven't given it much thought. The first thing I wrote before I got here, opposition was do a TUI request. And so I see that at the end of that, that's exactly what we're doing. We'll get to that in a minute. So I've read all the pleadings. I have looked at some of the law that I want to look at. There's one thing that I didn't get a chance to look at this morning, but I'll hear from you. And perhaps the best way to do it is to just go item by item and identify. I think it pretty clearly now identifies where there's a variance. If you wish to be heard on any of the orally, I'll certainly give you the opportunity to do that now. If you want to rest on the papers, that's fine too. I may have questions as we go through. But why don't we all just turn to paper number 32 and go through those now.
Would you like to start?
Sure.
I think by and large, I'll just rely on this plea that we filed after the Commonwealth.
All right, that was that hearing from Massachusetts that was yesterday, and we wanted to replay that for our viewers. Meanwhile, here in Conway, South Carolina, we are continuing to follow developments in this case here where the defendant, Christopher Duntel, has said that he wants to plead guilty. We'll have all the latest when we come back.
Oh, I hate when they do. No way.
Well, welcome back to Court TV Live. I'm Julia Janae. Thank you so much for following along with us this afternoon. We have been in several courtrooms today, a lot happening here at Court TV. Our legal correspondent Kelly Craft is going back into the courtroom there in South Carolina, where we are following that breaking news that the defendant in the Coroner Affair murder trial is deciding to dealing the questions about ethics and how it handled was lasting. Anna's body has never been found, and her husband, Brian Walshe, was last in court in October, where his lawyers raised questions about the integrity of the Norfolk County's investigation. You'll remember this is the same county that handled the Karen Reed investigation, where there were a lot of questions about ethics and how things were handled. That October hearing for Walshe was continued until yesterday in order to give these parties time to review the large amount of discovery. That includes cell phone data from Trooper Michael Proctor. Another name you'll remember. He was the lead investigator in the Reed case. Let's go into court now. We're listening again to that discovery hearing that eventually is going to mention Trooper Proctor.
After the Commonwealth and the defense sat down on a number of occasions and worked through this. By and large, Judge, what we're asking, just turning to page 2, paragraph 1, subparagraph A.
Yes.
We continue to ask for disclosure. I understand the reality of this is that they've engaged an attorney who I am familiar with professionally. And like I say in our motion, we don't object to Attorney Sack being assigned to review. So we have no objection to him. And I'm not familiar with Jim Carney, but I have no objection to Jim Carney. It's just that we believe, based on the existing case law and the citations that I've provided in the memorandum, that defense counsel is in the best position to assess the exculpatory nature and the utility of this information, whether it impacts bias, credibility, or the Bowden defense of the conduct of the investigation. And for those reasons, and I'll leave it at that, we ask that this material that the Commonwealth declines to turn over be turned over. Other than that, that's all I'd have to say on that particular issue.
So, Your Honor, I can tell you that not only did we retain Attorney Stack, and he's received the download of the phone. I am also going through the phone through all of the emails and all of the text messages and anything that could be a statement to try and find Brady material. But I'm also focusing in on Rule 14 statements, and I feel it's my duty under Graham and McFarland to go through this myself and find anything that could be potential bias, but also statements, and I'm doing that. I focused in on all
I'm
of
happy to
it.
hear that, because you'll find that I try to be as transparent as I can,
Yes,
to
Your Honor.
both sides. And when I read this, I don't know Attorney Sachs, and I don't know the computer person either, but
Yes, Your Honor.
this is interesting. Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it. But I've seen special ADAs, special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And my initial response, honestly, was, I don't think they can do that. I don't think they can delegate that responsibility to an attorney. But it sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check
Yes, Your Honor.
for the consultant.
That's the purpose of Attorney Stack. Is not to outsource it, but to double check with the Commonwealth this time.
Okay,
And he's doing it independently.
all right, that's always good to have another set of eyes, I suppose.
Yes, Your Honor.
All right, anything else that you want to talk about with regard to this beyond what's in the papers?
Not beyond what's in the papers, Your Honor. We pointed out that there's sensitive material in there about ongoing investigations. Turn over the phone wholesale would be problematic and could jeopardize ongoing investigations. And as a result, that's one of the key issues of why we can't turn over the phone wholesale.
By the way, what I'm probably going to do is following this hearing is I'm going to give you an omnibus order on discovery. I'm going to follow your sort of how you set up the issues, because it makes sense. And so I'll just go one, A, B, C. It makes sense. And I'll probably be doing that more quickly than I thought it was going to be. My trial was supposed to start tomorrow, just tangentially. So I'll have an opportunity to look at this. While it's fresh in my mind, I'll get something out to you.
Yes, Your Honor.
I will tell you that the preliminary view on this is it's the Commonwealth's obligation, and that nothing that has happened or that I've read so far turns that on its head. And the idea here that I understand that the defense has a very unique perspective on every piece of evidence that is just a different view than a prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information that I know. But that's just my preliminary view, and I want to give some more thought to the arguments that have been made. All right?
May I proceed?
Yes, please.
With regards to paragraph number 2, the request regarding the 3074 pages, I will defer to Attorney Kelly Porges, who at the time when we finish this motion, she'll be arguing the motion that addresses that request, I think.
Okay, that's the motion, paper number 31.
Yes.
I'll defer on that one.
We don't need to touch upon paragraph 3. We're waiting for production of those letters. Paragraph 4, we don't need to address because we're withdrawing that at this time.
Right?
Regarding paragraph 6 is really subsumed in Rule 17 that we'll deal with.
Part 5 is not an issue either, right?
5 is not an issue. I'm sorry. And once again, paragraph 7, that's assumed in the Rule 17 request, I do believe. Number 8, we all agree, at least the Commonwealth, and we agree that that's captured in paragraph number 5, request 5, and we need to deal with it. Moving ahead through now to request number 14. What we're trying to do is say that, argue that the Commonwealth needs to produce this unless it can make a sufficient showing of what it characterizes as the basis of its argument, that what we're asking for implicates the work product rule. And where I would agree that if the work product rule under 14A5 is in fact implicated, I understand that they would have grounds to say they can't disclose it. But I find it hard to believe that what we're asking for, that the entire universe is captured as work product. And so for those reasons, we ask that that request be allowed in so much as what we've asked for, that they.
Why isn't a good initial step to just say, have them, we commonly see this in civil litigation, but go through, but it's perfectly appropriate for criminal litigation as well, to go through and say, this is the basis for the work, this is, the privilege law, and at least give the defense then the universe of what the responsive documents are, and if it is Commonwealth's position that they're covered by work product privilege, there'll be enough information that you can make everybody can make some preliminary assessments. And if there are some that still can't get to yes and figure it out through that long, I may then entertain looking at them myself, but I don't think that that's necessary as a first step. What's the Commonwealth's view with regard to privilege law?
Your Honor, there are some items that would be distinctly privileged that we would have the burden to show. That being said, the Commonwealth is producing any and all notes written by any of the officers, investigators in this case.
I saw that.
In reaching out to, we've also produced any and all notes and reports from the crime lab. Reaching out to OCME to see if they have any additional notes. So the only notes that I can think of that aren't being produced would be mine. And and my notes would be on scheduling, strategy, theories, thoughts on the case. And so at this point in time, those would be worked on.
All right. Do you have any objection to putting those in a line?
I would, yes, Your Honor. Well, because
all I'm asking you is from the date, if you have it on your notes. If it's an internal note to yourself, that's it. Internal note, 88 Connor. Date. I'm not asking you what's in there. You can say
it's just
you can
not
say as blandly as trial strategy, if that's what it is.
Well, my notes might not reflect dates so much as where I am sitting at my desk writing down theories. So the best I could do would be to say.
You're not asking for that, Attorney Tipton, right? No. You don't want.
So I will go through my notes and see if there is anything that would be discoverable under Rule 14. But as of right now, I can't think of anything, but I will double check. And if it gets to the point that I have to create a log, I will. But I will see if there's anything that contains a statement under 14.
All right, if there's if this is a series of notes, it seems like an exercise of futility for you to have them do the log. I'm just saying if there's something more complicated or complex than that, because I'm clearly not giving, you don't want them, you're not gonna get them. So if it's something more than your notes, something going back and forth that reveals strategy, perhaps with you and the investigators, I'm not gonna produce that either. But he wants a record, and he's having Attorney Tipton's, credibly saying that he doesn't think that that's the whole universe of what would be out there. It may be.
And so, Your Honor, if we're talking about communications, separate from notes, like I said, I'm going through the emails and text messages that are in the phone. And if there is anything in there that's discoverable under Rule 14 as far as a statement of the witness, that's going to be turned over.
Sure.
And I intend to be as liberal as possible, understanding what could be 14. But if there is something in there that is trial strategy, and I think that it could get to that point, we're talking about statements in the phone, then I would create a law.
Okay,
I would create a law. That it seems like the appropriate way. If we're talking about the phone itself, when I say the phone, I'm talking about Michael Proctor's work phone.
right.
I'm not looking to go through every person's phone. I have no knowledge of what is in every other person's phone. But Mr. Proctor's phone is distinctly in the custody and control right now, with a download of it of the district attorney's office.
Okay. All right, so with regard to that, let me finish by saying, any notes, and you'll see this in the omnibus order, any notes that are internal notes to prosecutor, I don't need to see that on the privilege log. If you want to revisit that, Attorney Tipton, you let me know. If there's something that comes up in the course of your review of the phone that is of the sort, I know it varies a little bit off of what we're talking about right now in this particular request, start making a privilege log.
Yes, sir.
And obviously share it as it's being updated.
Yes, Your Honor.
Okay?
All right, we're hearing a lot inside of this courtroom. We're hearing about Rule 14 there in Massachusetts, which is the rule, criminal procedure rule, that requires that the prosecution disclose things to the defense, especially items on his phone, and not what make the case. The defense launching back a accused of killing his wife. Brian, Norfolk County investigator. October hearing, we're hearing things on the stand. Defense. Let's go back from Trooper Proctor's phone.
Focusing our attention on both paragraphs 15 and 16, I think I can just argue these both together.
Sure.
And the gist of this is our request is because the Commonwealth has said they are not in possession of anything and any knowledge at this point, my subparagraph F, really what we're asking for then is to make sure that the Commonwealth, in an affirmative fashion, requests cellular records and text records of the Cohasset police that would impact and bear on bias, credibility, or the investigation. And I say that because without an inquiry by the Commonwealth of its agents, that being the Cohasset police, we really have no way of seeking this type of information. But more important than that, that given what we now know about what has and may have occurred within the ranks of the Mass State Police assigned to the District Attorney's Office. And I'll just add, without trying to sound hyperbolic about it, but in the Boston Globe today, there was yet another report talking about the failings, if you will, of the Mass State Police in the way it disciplines its officers and the way that certain officers, at least one, was promoted even after significant complaints were made. I think to fulfill McFarland and Graham and the requirement of Mass Rule Criminal Procedure 14A3, that the Commonwealth should be required to inquire specifically whether the Cohasset police have checked, and I'm not talking about all the police officers, I'm talking about the Cohasset police. There's 3 primary officers involved in the investigation of Mr. Walsh, to see if they have anything that comports with, and who knows if they would disclose it, but I would hope they would, comports with text messages and emails and cellular phone records that indicate a bias, a prejudice, and a lack of professional integrity when it comes to investigating Mr. Walsh. And I will say that it was the Cohasset police, and I'm not casting aspersions on the Cohasset police. I'm just saying that if it's out there, the only way to really get to the bottom of it is if the Commonwealth fulfills its duty of inquiry and then returns back and tells us. I leave it at that.
Who are the 3 Cohasset police officers you speak of?
Schmidt, Lopes, and the third name is eluding me right now.
Maybe you can
Well,
Did you have a third name? Or,
I would suggest that Harrison Schmidt and Anthony Lopes were the lead investigators for the Cohasset Police Department. Several Cohasset police officers did aid and help. So there, if you were to say that there was like a B team that was helping with the initial investigation, that would be more than just those two officers. But Lieutenant Lopes went to Washington, D.C. and did some investigation, and Sergeant Schmidt has been the case officer for the Cohasset Police Department. So, Your Honor, as far as a duty to inquire, I am happy to inquire of the Cohasset Police and the state police investigators to see if there are any statements in text messages or emails that fall under 14 or are exculpatory, for instance, under Brady, McFarland, and Grant. I'm prepared to do that. That being said, cellular records is a bit more of a problem because I don't think a cellular record, whether it be a call detail record, would necessarily show anything. It would show maybe a call takes place, but I can't tell you that that call is about the Walshe matter.
and well, and that's what I wrote in my notes next to C is how would a telephone record tell you whether it related to this case or not?
Well, they just apologized for being unclear about that. I should have been much more specific. I really wasn't looking for phone logs or anything. I was looking for something that was contained on their cellular phones, such as whether it be emails or text messages or the written word that would be indicative of bias, and credibility issues. I am not interested in, at this point, of looking at phone logs, and I apologize for not being more clear about that.
So with that, I would inquire of the officers.
All right, so we have a break.
Yes, Your Honor.
The judge is taking a break, and we are going to bring in our trial attorneys who are standing by. National Trial Attorney Michael Jaffer and Criminal Defense.
Murder today.
No.
Absolutely bizarre, different world. Basically, criminality, in my opinion, is down to almost a halt in terms of being
Bias against Walshe. Let's go back into court for more of that hearing.
Okay.
Moving along, number 17 with withdraw
Yes.
as we continue. Number 18. And once again, if I could just point the court's attention and the Commonwealth to subparagraph G. That is one of G. That's one of the most inartful sentences I've ever
I
drafted.
don't want to hear what I wrote next to that.
It probably you said something a lot more stern than inartful, but it's what it was meaning, what it was meant to convey was that I'm sure the government is aware of the fact if something in their possession was destroyed or altered, and they would tell us that. I've been working with this DA's office for 2 decades.
Right.
So when I read that this morning in preparing, I cringed because it suggests that they're unaware of their own mistakes. And
That's how I read it.
what I was trying to say was, when they respond that they're unaware of anything being destroyed or altered, at least by their office, I take that at their word, and I understand that. So what we're saying, though, is, once again, a duty of inquiry, and a very specific inquiry of its agents to find out if anyone else is aware of something being lost, destroyed, or altered by way of, whatever that is, if it has to do with the investigation of Mr. Walshe. And I think a duty of inquiry is required under the facts and circumstances and what history has told us now, the recent history of the conduct of some officers involved in the investigation of this case. And so that's really what we're asking for, just an inquiry at this stage to make sure that there is an affirmative statement on the record that after inquiry, there's no knowledge of anything being altered, destroyed, or created.
Okay.
I appreciate Mr. Tipton, his honesty on paragraph G, because I was confused as well. Because when it comes down to it, is at this point in time, I don't know if something is lost or destroyed. So if I find out, that would be exculpatory, and under the rules, I would have to tell him. So I would tell him. I guess what Mr. Tipton has asked me to do is to actively go and ask every officer if anything is lost or destroyed. When I do my inquiry, I will ask if anything is lost or destroyed.
Sounds reasonable.
Okay. I think that's it for now.
That was faster than I thought. All right. Do we want to address paper 31 and whatever the column's been docketed as the next entry, which is the, I'll call it the 2/8 appointment. Now that the defense is seeing what the column intends to do, is that, I mean, that seems to me the way that we get the information, if they're going to get the information.
Respectfully, Your Honor, they have the information. The information is in the custody of the Norfolk County District Attorney's Office, so not only is TUI unnecessary, it would still be premature when you look at the cases such as Donahue and Lehman.
What if I'm not persuaded by your argument that I ought to be persuaded by this Rahim case, which I frankly am not persuaded by?
So the first question is whether or not the documents are under the purview of Rule 14. We believe they are. We're kind of at a disadvantage because, one, we don't have a copy of the protective order or the non-disclosure agreement. So we're at a loss there because I can't specifically articulate what exactly the protective order is, what exactly it covers. And two, we can't even articulate what is in these materials. The importance of Rahim is that if it is physically in their custody, then they have received it. It is in their control, they possess it. Just because a federal agency says, no, it's really ours, it's not theirs to give.
That was very much so in the context of a joint investigation, right?
It was, Your Honor, but in this case, the government, the federal government and the Norfolk County District Attorney's Office were essentially working together. They were working to investigate a homicide that Norfolk was prosecuting. They were investigating the state police for integrity violations, policy violations, inappropriate conduct, failure to supervise. And so this information has been starting to get turned over to us. And as Mr. Tipton articulated, whether it comes to Bowden or credibility.
Whoa. Is she talking about the investigation that came from the Karen Reed case? I still feel like I'm missing something. So, because of all the crap that happened, because of the Karen Reed case, it's affecting this case, as well as the case with, I forgot her name, but the woman that died that was pregnant, that it was made to look like a suicide. So these three cases are, in a sense, connected. So why isn't Judge Canoni still the judge on this case? Okay. Judy, if you are watching this, we need some research because I thought I was catching this at the beginning, but apparently I'm behind on this one.
Or bias. That's part of what we want to show and what we expect to show. So we believe the material is Rule 14. They have it, ergo we should get it. So I don't think TUI is even necessary yet. If they've indicated they're going to take that road, then that's fine, but that does not negate our argument that it is Rule 14. And the SJC as recent as 2020 has clearly stated that it is in their possession. With respect to the cases they cited in their response, they're relying on Como versus Bonnet.
We're hitting the pause button on this discovery hearing. We have to get to a break, but we stay with.
Convicted of man-sentencing.
There are coming.
9 years old, and Brian has never team on the pre-hearing.
Bonnet, which was a 2015 case. I don't believe that's on point. Bonnet is a case in which the state district attorney's office was not aware of the identity of a confidential informant. And so it wasn't in their custody. And secondly, they were saying that it was privileged. We have nothing to show that anything in those 3,074 pages are privileged or protected. We don't know. We've pulled it together from pleadings from other cases, responses from the government, just to know that they have it, roughly what it's about, and then several letters between the district attorney's office and the federal government talking about this material, specifically the officers involved. And the reason I can point to, there's a myriad of reasons why it would be relevant, but what we're able to determine is that Trooper Proctor, who was the lead investigator on this case, the moment he stepped foot into investigating Brian Walshe and the disappearance of his wife, he knew he was under federal investigation. And so his bias, his motive, anything or his integrity is forefront for him. So with all those thoughts, when you're considering all of that, I don't know how it's not Rule 14. I don't know how we're not already in possession of this. And so otherwise I'd rest on the papers. And they talk about Beal, your argument. In Beal, I agree the prosecutor doesn't have a duty to go investigate our case, but they haven't. So we're not asking them to go get something they don't have. And in footnote 4 in Beal, which is cited in their brief, it specifically says the government isn't able to simply put their head in the sand if there is something exculpatory. And documents that show that the lead investigator in a homicide case knew he was under federal investigation the moment he stepped foot in the case is certainly.
Isn't it even strong? Well, I'm not making your argument, but wasn't he already under prosecution?
No, Your Honor. Do you mean
So
Mr.
what's the
Walsh, or do you
yes.
mean, no.
What's the timing of his federal indictment?
Do you mean do you mean Trooper Proctor or Mr. Walsh?
I thought you were talking about Mr. Walsh.
No,
And there's
Mr.
a
Walsh
bias
is
because
state
he knew that
investigation.
Mr.
No, Trooper Proctor knew he was under federal
federal
investigation
investigation.
the moment. he
I thought
stepped
you were
foot.
saying there was a bias against your client
No.
because he was under
No,
federal law.
no, it's Trooper Proctor.
That's an additional bias, by the way.
Right, but we're just focused on that part. But the moment he stepped into this investigation, and bear in mind, the Norfolk County District Attorney's Office, they control homicide investigations. They work with the state police with CPAC. So now the Norfolk County District Attorney's Office knew that Proctor was under federal investigation, specifically for how he investigates supervision, et cetera. He now is the case officer in this matter while his case is pending. So that's one of the myriad reasons why not only are these documents relevant, they could very well be exculpatory. And under Rule 14, it's not exculpatory, it's material and relevant. And so with respect to that, I would rest on the papers, Your Honor. All right.
So, Your Honor, it's my understanding that the federal government has never said that they were investigating officers. That's never been a public statement by the U.S. Attorney's Office in this matter. They have released information to the Karen Reed prosecutors that was subject to a federal protective order signed by a judge that is impounded that I can't see. I have also not seen the materials that were turned over to the Karen Reed prosecution team. So I don't know what's in those materials either. I can tell you that I watched a large portion of the Karen Reed trial. And from what I could see, 2 witnesses identified that they had testified in a federal grand jury in that case, when they were testifying in the state Karen Reed trial. It's further my understanding that the federal government acknowledged that they were investigating the death of John O'Keefe, not the district attorney's office and not the state police. It's also my understanding that the U.S. Attorney's Office has not said that this investigation is done.
They never do.
They never do. I can say, Your Honor, I have no knowledge of anyone receiving a target warning as far as being a state trooper, the district attorney's office, Canton Police Department, any civilian witnesses. I have received no knowledge of anyone receiving a target warning. And I would suggest that this is premature, that I have filed a TUI request with the U.S. Attorney's Office for the Walshe materials. I told counsel today, I think I should file a TUI request for the Karen Reed materials. And I was willing to work with counsel to make it a joint request. I can understand if they want to do their own, but that would be my suggestion, because I would suggest under ALEA, we haven't gotten to the point of the need for the court to become involved in order discovery to be turned over, particularly discovery that was turned over. The people who have seen it would be a violation of a federal non-disclosure. So I'm not prepared to have someone from my office be charged with contempt. I would prefer that we go down the road of trying to work with the U.S. Attorney's Office and see what those results are, report back to the court, and let the court know.
All right. I'll take a look at the cases that both sides have cited, and I'll include whatever my decision in regard to that in the omnibus order as well.
And one last point, I don't think we can say that the U.S. Attorney's Office and the state police work together on this investigation in the matter of John O'Keefe. It looks like it has been completely two different agencies doing two different investigations. I don't see it there has been no sharing of information until there was discovery and turned over to the Karen Reed trial.
Well, Your Honor, it's not, the case law isn't just about specifically whether or not they worked on this case together, but if there is cooperation in general between the two agencies, which clearly there is. And the problem is, there's too much we don't know we think. I don't think it's, respectfully to Mr. Connor, I understand he's willing to make the TUI request, but I don't know how we say we're gonna make a TUI request, which when you send a letter to the U.S. Attorney's Office saying, we believe you have relevant material information, and then at the same time object to the Rule 14 of materials in their custody. That's no foreign.
All right, let's break this down with our criminal defense attorneys and trial attorneys who are standing by, Michael Jafer and Sam Bassett with us. Sam, we've got the dead.
I mean, you can't just, it has to be a court investigation.
Fine, completely.
They have a story that this other, but he tunneled to throw all of it.
At officers being where the I
think.
So,
Sarah, where I'm Anna. She was friend. Where is the lawyer's name counted until which were Michael case.
Murder of his wife talking
man again.
searching disturb more.
Oh, come on, get back to the hearing.
He's surveillance video. Police. He would be charged.
Rely on that at this point, but I understand it's right to be like, well, someone else in my office knows, but I'm just not going to talk to them about it. I understand if there's protective orders and if the government wants to rely on that at this point, but I think that not only is there evidence that these two agencies routinely do work together, I think the fact that the officers involved in both cases were under investigation for whether it's integrity, investigation, failure to supervise, I think that does count as working together for this case as well.
I would just disagree with that.
All right.
If I may, Judge, just briefly, I don't want to step on anybody's toes here, but when Mr. Connors just said that we didn't want to work with him, I will say we will work with him. I just don't want, and Attorney Porges don't want, that our efforts to work with the Commonwealth dilutes our Rule 14 argument. That's all.
When we get the lower hanging fruit, the Rule 17, when do you want to schedule that?
I reached out to Chief Legal Counsel for the state police. They asked for 4 weeks.
Okay.
So with
What does that bring us to?
We should bring us to the beginning of June.
First week of January specifically. January 6th through the 10th. I'm available.
All right, so, I want to get a date on the calendar, and recognizing you're likely going to be up and over for that one.
That's right.
And so I just want you to know that in advance. I'm happy to do what I typically do, and frankly, what I'll be doing when we try this case or whatever that is. I try cases from 9 to 4. And what I do to accommodate the other business, depending on the length of the case, is try to go on the bench at 1:45 and clear away the more straightforward matters. And frankly, put off the more substantial matters to a time when you're not on trial. And the goal there is to keep the case moving and to be as most respectful, frankly, as I can to the jurors who are making a big commitment of their personal time. So it becomes a little bit of a juggling act, but it's doable. You just do it for the 2 weeks. This feels like a 2 to 3 week trial for me. You're going to tell me later on down the line what it really is, but just on the limited knowledge I know, 9 to 4, Monday through Friday, it feels like 2 weeks, but I don't know enough about the science yet.
We're anticipating 4 weeks, and
On a full day schedule.
on a full day schedule. We were just talking about that before we came.
You're probably right. It doesn't feel that way to me, but that's only because you know a hell of a lot more about the case than I do.
We also know each other. We've done a lot of things with each other as far as trial work, and we know that neither one of us kind of waste each other's time. So we just believe that we're probably in that realm. We also think that impanelment will take 5.
And that my estimate was after we get the impanelment, which could be a lot.
Sure, Sam.
I was trying to include impanelment, so I think that if you're thinking about testimony, it's probably about 3 weeks.
So it feels like it.
Yeah.
But again, your estimates, I'm going to take your estimate to the bank because I'm just entering the case and you know so much more than I do about what it's going to take to try the case.
Yeah, sure.
So, but that's important and it's a good segue. Anyway, let's get to, the reason I mentioned that scheduling issue is I can see you at 9 o'clock in the morning if you want to do that, and I'll just delay my trial on that day till 9:30 or 10 if that works. If you don't like that, and I get that because you're going to have to deal with the 120 in traffic going up there, which is not good. I could see you at 1:45, and I'll give you 1:45 to 2:15. Or I could see you at the end of the day. Pick your time slot.
Whatever works for Mr. Pittman, I'm happy to do it.
The 1:45 certainly works for me.
All right, let's do the 1:45.
Which day?
Which day?
Any day, but Wednesday or Thursday or Friday that week would be best because the panel on the case tomorrow is probably going to take a couple of days.
How about January 9th, which is the Thursday?
That's the one date I couldn't do that.
So I picked it. How about the 8th?
January.
January the 8th.
At 1:45 in
Wednesday?
Middlesex?
Yes. And if the defendant wants to be there, obviously we can get him there. If you want to waive his presence for that, that's fine too. You just let the court clerk know and each other.
And just so the record's clear, I do have a manslaughter case scheduled for trial for January 7th, but I'm probably going to learn within the next few days if that's going to go or not, but I don't anticipate it going. I just want to.
Okay, if it is, we'll find another. I just want to keep everything moving to the best that we can, but, and I will be agreeable on trial, given the nature of this dispute. Also seeing you on Zoom. So, given the nature of the dispute, I don't know that we all have to be physically in the same room. I prefer that, but it certainly isn't necessary to get your points across.
Thank you.
All right. But right now, we'll presumptively say 8:25 at 1:45 in Middlesex, and I'm going to be in Middlesex 5:30, I believe. But definitely on the 5th floor.
Oh, okay.
Like a traveling judge or something?
All right. So let me move to the schedule. Let me see if I can find proposed schedule in order. Every judge has pet peeves. We all do. You do too. Yeah, your own pet peeves in your practice. One of my pet peeves is serial motions to suppress. I like to do them all at once. I never understood why you have a motion to suppress this, that, and the other thing. Just do it all together. Evidentiary, non-evidentiary, put it all together. So I want one date for the motions to suppress. Or put it all into, break it out if you want to break it out. But it's all going to be argued and heard on the same day. And so that's going to compress the schedule. The other question that I had about, these are just general.
All right, the judge saying, listen, it's a hard balancing act. I need to ensure that the defendant gets a fair trial, but also I've got
the George
Massachusetts, Brian Walshe. We want
For a relatively brief period of time, as you have it scheduled right now, between the motion to dismiss and the motion to suppress. So in my judge mind, I read one of two things. I don't think one is really coming and it's not going to change the schedule. Or there is one coming and obviously we're setting ourselves up for, we're not going to even get to the April date. So those are the thoughts that are running through my head. This case ought to try in 2025. I think we should pick a trial date in around a year from now. Now that you're telling me it's 4 weeks, I'm much more likely to look to November as opposed to, so when I was driving down here, I thought first week of December, we'll get this in before the end of the year. Maybe somebody could take a look at the calendar and see when Thanksgiving is. Maybe we do the Monday after Thanksgiving. I think we'll get it in 4 weeks, clearly there. But I think that kind of schedule should give you a reasonable amount of time to get the work on the important work that you need to get done. But keeps this case on a little tighter schedule. It's going to be, as I said, I think the case was arraigned in April 27th of 2023. So I guess the suggested time that I'm giving you is 2.5 years. That seems like enough time. Now, I said it a couple of times, I'm going to repeat it again, and I'll certainly hear you. You know the case better. When I see things in motions that say there's 27,000 pages of documents in this case, what does that really mean? I don't know, because I don't know what's in those 27,000 pages. Not all 27,000 pages are the same. You know what I'm talking about. And I don't know how much more is coming. But you can compare it to other cases tried here and certainly elsewhere in the Commonwealth and say 2.5 years, it's time to go. And that's what I'm suggesting. So I'll hear from both of you. Who wants to go first?
Well, Your Honor, I can say that as far as the discovery goes, it went in a couple different directions being the grand jury, which was about 1,000 pages, but I think it was a complicated case as far as pulling it together because there was a significant white collar portion to it. So with that, I understood how the discovery got up to there in numbers, but that being said, Mr. Tipton and I have had a long-standing relationship and working on cases together against each other, and I think that we have a really strong relationship on trying to get to the heart of the issues. We talked about trying this case in 2025, and we were looking at potentially late October, and I'm looking at the calendar right now in front of me, and I think October 20th, 21st is the second to last week in October. To me, that gives us about a month before Thanksgiving, which is a nice target. I think it also makes it easier to get the panel jurors. I think once you start crossing towards holidays, it becomes a little bit more problematic. So that would be my suggestion as far as the trial.
And just so you know, that's 6 weeks before Thanksgiving. That date that you just picked.
October 20th, 6 weeks before Thanksgiving.
Yeah, late Thanksgiving is again in May, it's November 27th.
So that's, given the panel being a long time, could be like over 5 days, could be 7 days, I don't know. I think that gives us enough time.
After talking with the district attorney and our client,
If that date is good for you, it's good for me.
Sure.
You want to go backwards or you want to? Which is that?
It's not mine.
Someone's media box has a phone or some device that's vibrating, so if we could shut that off, that'd be great.
I think it's stopped now. It's not. All right.
Do we want to work that?
Yes, we're gonna work that, right now. So what was the date that you just said?
So
October?
21st, Tuesday, October 21st.
Okay.
If I could,
I just want to add, is there any, does anybody want me to ask Civil to us start on the 20th? Might be a good idea.
Yes, please. It's been a few years since I sat here, so it's, what is it, Monday is the civil
Monday's
day?
civil, Tuesday
Tuesday and
is
Thursdays.
criminal and stuff, but
Actually, it
exceptions.
wasn't that long, I guess it was about a year and a half ago, just seriously. All right,
Judge, if I could just, before we start nailing down
dates, yes.
and just so you know, the Commonwealth, we all met, and we hashed over a bunch of dates too, and hoping that, the court would find those dates for you. But having said that, briefly, I'm just gonna say this. I didn't have the case for me.
I know, you came on board about a year ago,
I
right?
was in the middle of a double homicide when the case came up, and I really didn't look at anything for a few months. And when I say 27,000 pages, that's an underestimate. And included in some of that is video surveillance, hours of video surveillance. There's also transcripts of statements that still need to be properly transcribed in some instances. But aside from that, the forensic testing in this case.
Thank you for mentioning that.
Is extremely complicated and it's still ongoing. And the Commonwealth and I, Attorney Porges, we're trying to work out an issue with the DNA testing and the exhaustive testing that is a very critical aspect of this case. And we expect to be able to, file a motion to address the issues we have. But the short story, judges, I hope the court understands. When we selected the dates for the proposed scheduling order, that was after we met a number of times. We talked about what the case was, our understanding of the case. And I want the court to know that we didn't suggest dates as a subterfuge to suggest, we'll just pick this.
And I don't think that anything I said in substance, or certainly in my intent, sometimes it gets lost in my translation, in my delivery, was meant to suggest that that wasn't in the realm of possibility. I just think that it's probably not the best thing for the case. And I'm going to be here to try the case, whether it's in October or it's in April. But it's going to be tried in an efficient manner, and there's a reasonable view to, it's my pet peeve. I don't like serial motions to suppress. It's just as simple as that. But some people like serial motions to suppress. You don't know who you're getting on the other side of the bench. Some people like to take it in smaller tranches. I'm just telling you that I think there's a way to be more efficient. Of course, I'm not going to force or pressure anyone in this case within reason, and I'm never going to have to do it with counsel that I have here to make you do something that you're not comfortable going forward. I think we can be more efficient with the schedule. And I'm going to do my part to turn around the motions you do present to me quickly.
And on the vote just now, limiting to the issue of motions to suppressing the dates, after the Commonwealth and I, and Attorney Porges all talked, we think there is a need for 2 separate dates. And if we could, I would ask to come to sidebar to tell the court, to give you a reason that I'd like to do it sidebar.
All right.
While they're at the sidebar, let's bring in our experts this hour, trial attorney Michael Jafer, criminal defense attorney. I'm going to.
Here is everybody's trying to all
right.
So the okay that I had, Brian might need some
No talking heads.
unconscionable what he was saying.
Page of when something not potential case.
It's incredibly this case to this computer search I mentioned. Looking at under that, we found whether or 2020 or murder.
Let's congratulate Jeffrey. Are made so much for Walsh. Right trial date
go back to that so that we'll seek the 10/20 day for impanelment, and then we'll seek, I'm going to put you on the final pretrial conference. Let's do it 2 weeks out because there might be enough instead of, I don't know what they normally do it here. It's usually the week before. But this one, we'll put it 2 weeks out.
Mr. Tipton and I go on, start around 6 months out, and keep you busy until then, so, don't be surprised if we.
I'll be watching. I'm just like, we'll be on the final stretch of motions eliminate.
Yes, ma'am.
On, let's do it Tuesday, the 7th, is that right?
Yes, October 7th,
And then,
9 or 2.
I'm going to say 9.
I agree.
okay, so 9 a.m. for that, and that'll mean that, you're gonna have to back this out, but get your motions eliminated with any objections to me by the Friday before that. Earlier, if you can. If you can't, I'll just read them over the weekend.
So file everything by the 3rd, all motions eliminated by the 3rd.
Yes.
And any jury instructions, proposed voir dire. I don't know if you're going to want to do a questionnaire. If you do want to do a questionnaire, you can reach out to the court. I have a couple of ones that I've used recently and homicide cases, and I can give those to you. It does, in some ways, make the impanelment, I don't know if it goes faster, but it raises issues in a more sensitive way.
I appreciate that, Judge. We've been working on a questionnaire already.
Okay, great.
I would appreciate anything.
I'm happy to share them. They're available, and I think that every time you look at a different questionnaire, different issues come to light that you think might apply to your case, so I'm constantly tinkering with it. But I'll share feedback I've had in the last couple of years.
So, were you going to pick a date, give us a date for the filing of?
Everything's on that Friday before.
Okay.
Your Honor, if there are objections to anything that's filed on Friday, understand when it's written objection, we'll be getting to you.
Right. So what I was trying to build in was, and since I know that you work collaboratively, is I'd really like the whole package, like the 9A package, so to speak, together on that Friday before, so I can consider the objections, the oppositions. So if you can work collaboratively so that the oppositions are filed, maybe you give them to each other the week before. Your motions, if you want me to put that as a date, so initial motions eliminate are the Friday before, and the oppositions are the Friday before the 10th.
Motions by the 3rd.
Yeah.
File the week before.
So the 28th of September would be,
Yeah, you did that by September 26th. You'll file all
Thank you.
motions eliminated and your objections or oppositions filed by the 3rd.
That works for everybody?
yes, Your Honor.
Yes.
All right. All right. Let's do, I think we agreed to 1-2 on the motions to suppress.
Your Honor, we had 2 tentative dates for the board.
Sure. Thank you.
For the first motion to suppress, which we believe, forgive me, will be evidentiary.
Yes.
We were suggesting April 7th. And then the following would be for the remainder of the motions to suppress, May 12th. That would give counsel and myself 30 days to respond to anything that come up.
Okay.
Especially if you had a decision, would have time, the council would have time, or you would have time to examine it.
So, hold on a second, I just need to check something. Get the calendar from Okay, 4/7 is a good date. That's on the evidentiary one.
Yes, Your Honor.
All right. I am not going to be here, but I'm going to be close by, in that quarter as well. So just stay tuned for a location. But it's going to likely be in Middlesex as well.
That's right. 147, right?
Yes.
Yeah. And that's 9 a.m.
Yes.
Yeah.
And then 512. I can do that. I get to move something around, but I can do that. 9 a.m. also?
Yes, Your Honor. Also Middlesex?
Yes.
Thank you.
All right. Dates on the motion to dismiss.
So, Your Honor, I haven't talked to Mr. Tipton and Ms. Borges about this, but I don't know how they feel about July. So, July 14th, let's kind of smack in the middle of it, it's Monday.
Before we head to break, new developments out of Massachusetts where the judge in the Karen Reed case has denied the Commonwealth's motion to access Reed's parents' phone records ahead of her second trial. Prosecutors 20 times okay, to launch this case and find looking into it from Karen.
Court TV was the judge studying the opportunity
Following a hearing. That's why the remainder of
Again, 9 a.m.
Yes. All right.
Again, 9 a.m.
Yes. Just stay tuned for where that's going to be.
Oh, yes, sir.
But I'll try to get up there. So you don't have to be where I'm going to be.
Thank you.
All right. Any other dates we need to put on?
We have a potential motion about the DNA testing, Your Honor.
What is going on with DNA testing? How long is it last?
If you guys aren't subscribed, would you please subscribe? I would really appreciate it. Thank you.
At it, what needs to be done, what has been done.
So the lab has tested samples from objects taken from garbage that was located outside the defendant's mother's apartment. It's also tested samples from inside the family home for acid. What is at Bodie right now is tissue that was found on a saw in the garbage at the mother's apartment. That can't be done by our state lab. Essentially, these items put in a wax paraffin block, and Bodie has the ability to take slices from the block and do DNA testing from that. There are 6 samples that have the potential of having results. And so where we're at is that they have the potential of also being destructive tested at Bodie. And so that's where we're at as far as potential motion. Bodie has a different, and Mr. Tiffin can probably speak to this better than I can, has a different policy and procedure for outside experts coming and viewing their testing. And also, there's a cost. And Mr. Tiffin and I have been talking about the cost. And it has to be paid one way or the other. The question is Who's going to pay it? Is the government going to pay for all of it? And so we're trying to figure that out. That might be the subject of the motion.
Okay. Anything you want to add to that?
So the money issue will be resolved. I mean, we want $20,000 just to have someone stand there and watch. However, the real issue for us is the observation and what voting requires and limits any observer to see as compared to the Mass State Police and some other ones. So we anticipate filing a motion. We discussed it with the county, arguing that voting needs to at least change their protocols for this case, especially this evidence that's being examined. And we'll file a motion, and that's the two issues. The cost, which probably is not much to talk about. It's the other that needs to be addressed.
Okay. When can we do that?
I think we should probably do it on that same January date.
Yeah.
On the 8th, because I don't think it's going to, I think I'll file something that's, I can rest on the pleadings and we'll just agree.
All right, let's do it.
Yes, Your Honor.
Two of you work together with regard to when it's going to be filed and give each other enough time, obviously, to propose.
Yes, Your Honor.
All right, any other dates we need to set?
The only other thing is a discovery date, but I guess maybe we should wait and see. I know there's two, but there's other production of discoveries coming. I think when we come back, January 7th, we can put a realistic findings.
All right, I think that makes sense, Joe, and I think you'll have the benefit of my ruling at that point and know what additional I think you ought to be producing.
Yes, Your Honor.
The addition of that motion, does that change the Zoom option for January 8th?
It doesn't in my mind. If you feel differently, let me know.
I was intending on being there, but I know.
You're welcome. All of you are always welcome, wherever we are. But if it becomes an issue that we would have to cancel the hearing versus doing it on Zoom, then it would be my strong preference to do it on Zoom. So you have that option. Just let the clerk know what you're doing, and obviously, it does create, obviously, some problems if defense counsel is on Zoom and the defendant had a number of issues with the facility not putting them on, and then it gets delayed. And so sometimes if there's two counsel, one will come up and the other will be on Zoom. Just work to make sure that everybody's coordinated so we don't lose the date.
Yes.
Ever have the defendant transported to Middlesex and nobody's there. I'm sure that won't happen, but given that there's some moving parts, I want to just alert you to the prospect.
Now that you've said you're sure it won't happen.
All right. So I'll see you all on the 8th. Before we close, is there anything anyone else wants to raise that I did not raise?
Yes. Is a housekeeping matter about protective order?
Oh, yes, Your Honor. We submitted two protective orders. They're agreed upon without prejudice, but it relates to internal affairs discovery and potential bias that we've identified.
Okay. So just take a look at them.
Yes, Your Honor.
Joining us now on set, Court TV crime and justice correspondent Matt Johnson, who's been following this case closely for us. Really great to see you as always, Matt. Tell us.
Nice to see you.
Okay, well, that was eye-opening because I didn't know anything about that. But apparently it's kind of sort of tied in with the Karen Reed mess because Proctor was on this case. Wow, man, crazy. So I'm gonna have to go back, and I've never seen a discovery hearing, y'all. That's why I wanted to do it. And unfortunately, it was all wrapped up in a presentation with Court TV. It wasn't just a straight discovery hearing. That's why I was like fast forwarding through. I mean, Court TV is usually pretty good. Like, I've not had any problems with Court TV complaining about me using their stuff, but I'm also not monetized either. But I still don't want to like get on their bad side. So I was like, that's why I was fast forwarding through all that stuff. But I didn't know. I had no idea. I was just like, oh, this is like at the very beginning of a case because it's a discovery hearing, and I'd never seen one, and so I wanted to do it. Hey, Bill. I'm so glad I got done before your live stream. This is a weird time for me. I usually don't do live streams in the evening, but I wanted to look at that discovery hearing, and I had no idea that it had anything to do. Well, it doesn't have anything to do with the Karen Reed case, but it was like investigated by the same people. So they were under federal like Proctor was under federal investigation when he was investigating this case too. So now I'm like super curious, and I'm later gonna be googling this case to get more information because I hadn't even heard of it before. I'd heard the guy's name. That was it. Well, fix your notifications, Hillary. I'm done now, and y'all show up right at the end. I was like, where is everybody? Everybody bailed on me because at the very beginning, the judge said something about Judge Canoni, and I was like, oh my god, what just happened? Where is everybody? Somebody needs to explain to me what just happened, and nobody's here. It's like, this is why I watch this with you guys, and nobody's here to explain to me what is going on. But yeah, I started the same time Biggin starts, so I knew that was a mistake. But I saw it and I was like, plus I got my new setup, y'all. So Santa came early. He brought me a new desk. So I'm not on. See, you can still see my Battle of Geonosis poster. You don't watch Biggin? He's funny. So I've got one poster over there now. I moved to the bookcase with all my Star Wars stuff. And then I have my Christmas decorations. This is where the computer was. And I sat there. So the poster was to my back. That's the door to Shadows room. I got to finish putting my books in the bookcase. And I think we're going to put some lights around the Christmas lights around the poster. So I have room. I have my laptop here, so I have my second screen. Oh, and the old desk that was here, the reason I wasn't using it is because I had an old cat that didn't like to use the litter box. Let's just put it that way. So I was tired of being all like, I didn't have any room on the end of that table, so I couldn't like spread out to like write and type and all that. Like, I can't. I have all this room now. It's great. So my husband took the old desk and he cut off the part that was all messed up and left just like one little part because one part was not messed up by the cat, and he had the printer on top of that part, and it has drawers and stuff for storage, and he left that part, and it's sitting over here with the printer on top. And I said, well, let me just get rid of that old one. We'll put the printer over here. There's plenty of room. And he goes, no. And I was like, why? He goes, because you're gonna need that room. I was like, for what? And he says, just trust me. You're gonna need all the room you can get. And I was like, why? And he goes, just wait till Santa comes. And I was like, what are you talking about? So there's something under the tree that is going to go on this desk. I can, for the life of me, figure out what it is. So Yes, very bad kitty. Oh my gosh. But the weird thing is like, we're like, how come she poops in the litter box? She just pees everywhere else. And then one day we found a whole bunch of cat turds behind the entertainment center, and we were like, oh, yuck. She's not using the litter box. But she's gone now. She was old and just, I guess, just decided she wasn't going to get up in the litter box anymore. I don't know if, do cats do that when they get old? I don't know. That it's gross. So yeah, but we need a new dining room table too. There's spots on the table where like we've cleaned it, but it's like warped in little spots. I want to know what's coming too. I definitely want to know what's coming. When I first sat down here and turned the camera on to like see what the view was going to be like, it was so dark. And I was like, it's because of, see, you guys can see my blinds now. You know how when the light would come in and it like hit me in the face and I would like be doing this to like block the light? See all the missing blinds? So I'm like, well, I know why, because it was like I looked, you couldn't even hardly see my face. And I was like, it's because the light's behind me. So I was like, let's move the desk to the other side. And we had just moved it over there, and I hadn't even plugged everything back in yet to check the lighting. And I was like, oh crap, 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 crap. He's like, what? I'm like, the Ethernet cable's not going to reach to the other side of the room. And I was like, okay, what do I want? Do I want good lighting or good reception or good connection? Good lighting, good connection. Good lighting, good connection. Like I guess good connection's better than good lighting. So we hung because my ring light, um I don't know what's wrong. I can't get it to attach to the pole anymore. Oh, give him kisses for me. Well, yeah, it's night now, and that's Travis is like, well, why don't we just our our like how double pane glass gets like filmy inside sometimes, like I don't know, like moisture buildup or something. That's the way that the the glass sliding door on this side is, so you can't really see out of it. So Travis goes, well, why don't we just paint it black and then it'll just be blacked out and then the light won't come through it at all. I'm like, no, I'm not gonna do that. So he goes, well, we can just throw a blanket up over it. I was like, no, just it'll be fine. So I can't get my ring light. I don't know if I'm missing a piece or if it's the threads are stripped or whatever. So it won't stay on the pole. I don't know what I did with the pole. It wasn't around. I don't know what I did with it. Anyway, so we hung it on a nail on the wall, and but even with the overhead light on and the sun coming in through, it was like I was sitting in the dark unless I had the ring light on. So we'll see what happens during the day when I do this. But um, yeah, it looks great now. I'm really happy with it. And there was so much junk in this corner and on the table. The way I sat, you guys couldn't really see it. You get like a glimpse of it every once in a while, but um, so I'm just Travis is like, this is needed to be cleaned up for a really long time. I'm like, yeah, I needed the motivation to clean it up, and the new desk was the motivation. So, um, hi, G. This is your Aunt Debbie, and I love you very much. Um, yeah, I will definitely let you know what is coming because that must have been the heavy one. There's one that's heavy, and it has the. I'm so bad. It's in a box that opens like that. You know what I mean? Like where you lift up the lid of the box, like a keyboard box. So, because I told him I wanted a backlit keyboard, because this one is just a cheapy little came with a computer thing. So if I'm, if I don't have the lights on in here and I'm just in here messing around, I can't see. I have to have the lights on to type because I can't see it in the dark. So the only thing that I'm not happy with is that I had to take my mic off the boom because the steps is not made really to attach a boom to. I mean, I have a little shelf over here, but it's kind of in the way. So, but it works. You guys can hear me good, right? So, okay. Well, I guess that's it. I wish it had been better. Like I said, like without all the court TV garbage in it. But and I'm gonna have to look up this guy because it's crazy. It's another crazy Massachusetts thing. And who searches how to dispose of a body anymore? Come on. Don't everybody knows now you don't search that on your own computer. That's that's a no-no. You don't do that now. Everybody should know that. That's a huge red flag. You don't do that. So, between that case and the other case, the other case that's going on right now about the van life, they're calling it the van life case, but every time, in fact, when I first googled that, I Gabby Petito came up. So when I hear van life, I think of Gabby Petito. Um, oh, what was the guy's name? Dang, I forgot his name. Ferrazzo or something like that. They were celebrating their 1 year wedding anniversary, and he said his wife went psycho and he shot her in the head. And but then after she died, he stabbed her and dismembered her. No, that's not self defense. If it's self defense, as soon as you do it, then you call the police and you tell them what happened. You don't. So on Recovery Addicts channel, they started watching that on Friday, and I just didn't feel like watching court on Friday. I played video games all day, so I missed it. And then I found out about it, and I was like, great, I missed it. So I had to rewatch opening. I mean, not rewatch, but watch opening statements today, so that I know what's going on, so I can watch it this week. I don't know how long it's supposed to last, but I want to, and he's claiming self defense, so he has to take the stand. So I can't wait to hear what his reason for stabbing her was. And they were parked at his sister had rented a B and B, an Airbnb, because they were all on vacation together. So then he went to his sister's Airbnb and they went out to breakfast. And he's a tattoo artist, so then he went somewhere and they did his sister's tattoo, and just like nothing was happening. He said, "Oh, she's still asleep." And then later they went out to dinner, and um, she wasn't there, and so we had an argument, and she just walked off, just walked away. Then and they lived with her parents, so then he goes back home, and she's not with him, just like Gabby Petito, and says, "Oh well, we had an argument, and she just left." So crazy. Do people not know how to get a divorce nowadays? Like, I don't. Okay, well, I will let y'all go. Thanks for showing up at the end. Make sure you guys are subscribed, And oh yeah, Brian Walshe. Yeah, this they did. They had, I think it said 3 kids, and they're in the Child Protective Services custody now. So I guess that means they didn't have like grandparents or people that could take them. That's so sad. So, and she was 39, so I'm guessing the kids are pretty young. Because I mean, well, I don't know how old she was when she had them. I guess they could be teenagers. I don't know. That's just so sad. So, okay, I'll let you guys go, and I will see you. So the 12th is the Karen Reed hearing, and the 14th at 10 o'clock is the Christmas hangout party, whatever you want to call it. Um, and we're just going to hang out and talk about Christmas stuff for a couple hours. And I'm trying to find some old Christmas pictures. I have some when I was little, in some scrapbooks. I'm going to take pictures and put them on the computer and show you. And that's it. Oh, no, I'm going to show you guys how I make my favorite Christmas cookie, because it's really, really easy. And now that I have room, because I was trying to figure out, how am I going to do this? I got a room. How in the world am I going to make these? Because they're no big cookies. Like, how am I going to do this? But now I can make them on the end of the table and just turn the computer, and you guys can watch me. So it'll be really easy and really fun. So, okay. So I will see you guys Thursday at, I think it starts at 11. Yeah, it does. Because I was stupid and made a doctor's appointment at 10:45 that I'm going to have to call and change. So I will see you guys on Thursday, and I love you and I appreciate y'all. Thanks for coming. Bye.